Good afternoon. Good evening. Um, it's Tracy B from the Divorce Solutionist. I am here for Thick of It Thursdays, which is me going live every Thursday at around the same time, 4 o'clock Eastern Standard Time. And I usually discuss topics that are related to divorce and or custody. Sometimes I choose a specific topic, and sometimes I just go through cases of not cases, fact patterns or situations that I pick up from either the groups that I'm in, consultations that I do, or forums, or just any random source that I may come across that I find an interesting topic or a topic that's pretty popular or I think needs further explaining. I will do that here, Thursday, here, 4 o'clock, here, live, here on my business page, the Divorce Solutionist on Facebook, or in my groups, the Divorce Glow Up, or even on my YouTube channel, the Divorce Solutionist YouTube channel. So today I decided to read a specific question or situation that someone in a group that I'm in posed. She wanted information, she wanted some insight. Sometimes I just tweak it a little bit just to make it a little bit more intriguing or interesting, or so that I can actually delve into explaining more of the laws or the statutes or the procedures that would apply to that particular fact pattern. So today, you know what? I actually thought I screenshot one specific case I liked, but I don't think, you know what? I actually might do two because these were interesting and they're not pretty long. They're not that long, but so one topic is child support. I rarely discuss child support because, and I do that for a reason. Child support is something that I know a lot about. It's just it can be very polarizing. It doesn't matter which group I'm in, who I'm talking to, age, gender, socioeconomic, demographic, it doesn't matter. It can be very polarizing to talk about child support. Why? Because there are some people who think suing for child support is an indication that you are, as a custodial parent, that you are not capable of taking care of the child if you have to sue for child support. Therefore, you shouldn't have custody. And then there are people who have come from the school of thought where not making the other party responsible for providing for their child financially is just allowing or enabling irresponsibility and unaccountability. So, I mean, and I can go on and on and on about positions people take that I consider polarizing when it comes to child support, but I'm not, because that's not my objective here. My objective here is to enlighten you about the laws, the statutes, the procedures, the view from the court, from the bench, pretty much, and the lawyers and the GL and the whoever else the players are that have a say or have an impact in the outcome of child support. So this one was interesting because um, this topic comes up a lot, and in my years of practicing, I found some ways and some methods and some tricks to help sort of address this issue, but nothing is really across the board as far as I'm concerned. That's my experience anyway. I don't know if anybody out there has any other insight, please feel free to chime in. So this one is really, really short and really, really quick, but I thought it was really interesting. So it says, we get irritated about how the bio dad works under the table to avoid paying child support. But what about when the roles are reversed and it's the mom who works under the table to get more child support? And I chose this because I'm trying to think, how many times have I actually ever seen that? Not often. In my years in the family law industry, I don't think I've ever seen a mom intentionally work off the table, under the tables, or off the books to increase her child support benefit that she gets from the non-custodial dad. But I'm sure it happens. I mean, this particular person I'm assuming she's the bonus mom for her to mention this because it's a woman, and I'm sure she's not I'm sure she's not. Maybe she is. I don't know. I'm sure she's not talking about herself. But anyway, and so from this perspective, I mean, if anytime any party, whether it be non-custodial dad or a custodial mom, who deceives the court by taking a job off the books, first of all, taking a job off the books and off the table is not illegal as long as they pay taxes. If they report their income, their real income, and they pay taxes on it, it's not illegal. Okay, that's not illegal. What is illegal or unethical or deceptive is if they make a $500 a week and they only report $3, or any deviation from that, and or they don't report at all. That's where the problems come in at. So for child support purposes, just because someone works off the books, that doesn't automatically indicate to the court that they are doing anything wrong or deceptive. But if there is if they're working off the books or under the table just to be deceptive, for what, it doesn't matter what their reasons, child support, taxes, whatever, if any other benefit, if they're doing that to be deceptive, then that's where the problem comes in at. The problem for the one challenging that is proof. So how do you prove when anyone, whether it be custodial mom or non-custodial dad, are working off the book, how do you prove their actual earnings or income if they're working off the books or under the table? I'm going to use those terms interchangeably because it's the same thing. And it's basically when you're not a 1099, you're not a W-2, you're just merely being paid in cash or in kind. So how do you prove that, though? One thing I did when I was practicing is I would prove their income by their standard of living. So if, for instance, someone is working off the books and they're claiming they make $300 a week, which is what, roughly $1,200, give or take, a month, but they're driving a car where we know the value of the car is like $60,000, and they live in an area where the insurance is high as heck, and then they're able to, maintain a certain lifestyle with other things, then how in God's name are they, unless they're like, if they have, a spouse or a paramour who they help share expenses, that's something different. But when you know that they're living solely off of their income and they're claiming that they make $300 a week, but their standard of living doesn't match that, then that's when I would start asking questions. I would start implementing the use of discovery, and, et cetera, et cetera. So proving it is a whole nother baby. It's a whole nother baby to prove what somebody actually makes under the table. But the bigger issue here is that some people think that mom's income doesn't matter in child support calculations. So it doesn't matter that she's working off the books or under the table. So it doesn't matter how much she's reporting or not reporting or actually earning. That is the case for some states. Some states, it's an automatic calculation of the non-custodial dad. And I'm only saying non-custodial dad in this particular hypothetical because that was the fact pattern I chose. Non-custodial could be the mom. It doesn't matter. So I'm not being biased here. I'm just going by the fact pattern that I'm reading from. So in some states, if mom is the custodial parent, the child support calculator guidelines, statute, factors only factors in the non-custodial dad or the non-custodial parent's income. It doesn't take into consideration mom's income. That's not the case in every state, though. So in some states, mom whether she reports her under the table income accurately, it does matter. It does matter because it can reduce the non-custodial dad's child support obligation. It can offset his obligation by, I can't tell you by how much because, every state is different. Their calculations are different. Their guidelines are different. But it's not across the board. So if you're in a state where the factors, where the guidelines take into account mom's income, then you need to know exactly how much mom is earning. And again, like I said, there are ways to do that. One thing I almost always use in child support cases where either side works under the table or off the books, and that is discovery. Discovery is requesting information, requesting documents, requesting a deposition maybe. It depends. It depends on what's at stake. But anyway, that was a short one. But I wanted to bring it up because it was a unique situation. Unique in a sense where like I said, in my years of practice, I don't think I've ever had a client that I represented as the mom that worked off the books intentionally. No, I don't remember. I might have, but I don't remember. My brain is like fried. Anyway, so that was one. That was really brief. That was really short, but I just wanted to get that one out of the way. The next one is more along the lines of topics that I generally choose. So one thing I often talk about, because I often get asked about, is being a guardian ad litem, or being a law guardian is what it's referred to it in some places. Some places I think they call them friends of court, or this particular case, they are called the parent coordinator. Now, let me just make this distinction. Some states or jurisdictions, they use law guardian / guardian ad litem and parenting coordinators. They serve two different purposes. Some states use one or the other, okay? There's no across the board. You need to know what your state procedures are, okay? It's not across the board. This particular state, I don't know which state she's in, but I'm going to read you the fact pattern, and then I'm going to go through it and analyze it. She said, "We've been using a parenting coordinator that is very biased." Now, in this particular state, I'm assuming they use a parent coordinator in lieu of a law guardian or a guardian ad litem, because most states that use both, the parenting coordinator's job or their role or their duties and responsibilities is usually limited to the logistics. They're usually limited to just coordinating visitation, like making arrangements and facilitating visitation. They don't get too involved with making observations and reporting to the court about, the best interest of the child. They usually don't do that in jurisdictions where they have law guardians or guardian ad litems to do that. Okay, there's a distinction. I have to stress that there is a distinction. In New Jersey, for instance, parenting coordinators or parent coordinators are usually used only for the logistics, facilitating visitation, exchange, drop off, ironing out the kinks, that sort of thing. But in this particular fact pattern, I'm assuming that the parenting coordinator is used for more of in the best interest of the child role, a law guardian or guardian ad litem. If I stand up to him, I get retaliated against in some way. That is a big, big problem. A parenting coordinator should not be biased in any way. I get it. We're all human. Because I was a guardian ad litem. I was a law guardian. I'm sorry. I was a law guardian, which is the same thing as a guardian ad litem. And I took my role very seriously. I knew what my role was, and I made sure I stuck to the rules. Okay. But some people don't. We're all human, so we do have biases, and I do too. But I try to make sure that when I reported, that I didn't let those biases, or even when I interacted with the parents, I didn't let those biases be known. My ex gets away with everything and doesn't follow our agreement, and he enables his behavior. I've documented everything. I'm tired of being pushed around. My ex said he doesn't need to read our family wizard emails, even though he doesn't know the content. I told the parenting coordinator until he addresses my ex and mandates he reads my emails, I refuse to go back onto our family wizard. Because if I did this, he would be sending him statements. He would be sending his statements to me, requiring me to read my ex's emails. Is this the best tactic? No. No, it's not. You can't do wrong because the other side is doing wrong. And I used to tell my clients this all the time. You know, you can't fight wrong with wrong. You can't do that. You know, and I know it kills us. I know, and I have a huge ego. And those of you who know me know I fight I play to win. I fight to win. But there are times when, you know, I am a big believer and advocate of the art of war and chess. Divorce is chess. That's my motto. Divorce is chess. Sometimes you have to use tactics that are not low. I was trying to come up with a better word, but yeah, for the most part, you have to, when they go low, you go high. Michelle Obama. And so this is an example. So now you're documenting everything. Okay. So are you documenting when you start to do things that violate the order? Because I'm sure he will. So now you have all this documentation to present to the court. Guess what? He has his own list. He has his own to counter whatever it is. And what do you think the judge is going to say? Oh, well, she was justified. No, you can't bank on that because the judge may not say that, especially if it's a court order. Under no circumstances do a judge like his orders ignored or violated, especially just because the other side did it. Well, he did it too, Judge. No. If you want a tongue lashing real quick, do that. Try that and let me know how that works out for you. So no, that's not the best tactic. You can't. Okay, so there's two issues here. You have a biased parenting coordinator and you want to violate the order, an order. I'm assuming it's in order for her to say that. Our Family Wizard. Our Family Wizard is a communication app for parents to use to co-parent. It's an app you download on the phone, and you know that's the way you communicate, so that conflict is kept to a minimum, unnecessary harassment and all that stuff is kept to a minimum. Most parents communicate solely through that app, and a lot of times it's court ordered. A lot of times it will be included in the court order when there's a history or allegations of abuse or, you know, not necessarily physical abuse, mental abuse, emotional abuse, harassment, stalking, you know, just whatever. So I'm assuming that this was court ordered too, that these parties communicate through Our Family Wizard. So let me go back. So the first issue about the biased parenting coordinator. Most jurisdictions do not have a set procedure in place for reporting biased parenting coordinators or guardian ad litems or law guardians. And when they do, you strategically want to think long and hard about doing that because what does it mean? What will happen? Chances are they're not going to be removed from the case. Now, they can remove themselves from the case, but you reporting them won't necessarily get them removed from the case. It actually might do the opposite and make them, if you think they were biased against you before, they may become even more biased. And they may not even have to say anything. It may be the judge who looks at you as you being the problem just because you're complaining about the parenting coordinator, law guardian / guardian ad litem. So you have to be careful about that. So what I always suggest people do when you have a biased, I'm just going to say best interest of the child advocate, because it's too much to keep saying PC, JL, LG. So I'm just going to say best interest of the child advocate, because that's what they do. What I suggest is that you and your lawyer, if you don't have a lawyer, you yourself, You just make a point, make a document of all the biases, all the interviews, all the behaviors, all the responses, all whatever you think is biased, how they showed you bias. You compile a list. You first may want to bring that to their attention to let them know that that's how you feel. Do it professionally, either letter or email. Don't yell at them. Don't accuse them. Don't attack them. Don't do that. Do it professionally, tactfully, and fairly. And if that doesn't render you any favorable results, then unfortunately, there's not much more you should do after that. But if your case goes to trial, you could actually cross-examine that particular witness. They usually have to testify in a case because they usually have met with your kids, met with teachers, doctors, or talked to teachers, doctors, etc. And so they usually have to not only report to the court, but a lot of times they have to testify. Either way, you can impeach them on the stand about the things they said or did that showed bias, or you can impeach their report. It depends on the evidentiary rules that are in place for your particular jurisdiction. So that's how you should approach a biased best interest of the child advocate. Okay, you should never, not never, you should hardly bring it to the court's attention, especially if you think the judge was already not necessarily in your favor. Okay, you should definitely think long and hard about making a complaint to the court about a biased best interest of the child advocate. Okay, I suggest, like I said, professionally letting them know in writing. And then if that doesn't render any favorable results or get any changes, then you might want to wait until trial and cross-examine them, their report, their observation, their assessment, whatever it is. Okay, that usually does get you somewhere, much more than just complaining to a court about them being biased. Okay, so that's one issue in this particular fact pattern. The other one is, like I said, the party choosing to defy a court order and not communicate with the other parent through our family wizard. Again, under no circumstance should you be defying a court order, violating a court order, especially just because the other party is doing it. You still want to do what the court order directs you to do. If you think that there's a real legitimate reason to not comply with a court order, your recourse is to file a motion to modify, to enforce, a contempt for the other side not doing it, but you just don't want to take it upon yourself to just stop complying with a court order. Okay, especially under these circumstances. There's no danger. Okay, it's just an inconvenience. It may be unfair, it may be burdensome, but it's not enough to say, you know what, I'm just going to flat out ignore this court order. Okay. So those were the two issues I wanted to talk about today. I don't have anything else right now. I did want to talk about something totally unrelated to the topics, but I just wanted to bring them up. And that is, so I was talking to someone today, and I was doing a consultation, and he didn't quite understand what I do. So I wanted to take some time to explain again what I do. Okay. I am a former family law attorney, mediator, guardian at Litem. Okay. Now I am actually working on recertifying to do some mediation again. But right now I am a divorce consultant / coach / strategist. And what I do in that capacity is I help people. Doesn't matter who. Doesn't matter if you're represented or not. I help people package their case, package every step of their case so that it's presented to the court to get the outcomes they want. So that means I will coach you through preparing for a GAL interview. I will coach you through preparing for trial or a hearing. I will coach you through choosing a lawyer if you need. I will coach you through motions. I will help you, write your motions properly. I will help you gather evidence and to organize evidence and to prepare trial notebooks. I will coach you, I will consult with you about whether your lawyer's suggestions for settlement are the best for you. I will listen to you gripe about what you're going through, and I will coach you with emotionally mastering your emotions so that you will, when you're in court or in negotiating settlements or in mediation, that you're more focused and attentive to what's going on. I will be there to listen, to guide, to uplift, to enlighten, to strategize, to prepare, to whatever it takes. My mission, my goal is to help you package, present your case so that you get the best outcome for you, so that you get the outcome you want. Okay. So, whatever that takes, that's what I'm here for. Okay. I do research. I speak with other lawyers. I'll speak with mediators. I'll speak with financial experts. I'll speak with whomever you need me to talk to. I'll read your motions. I'll read your discovery. I'll read your transcripts. That's a big thing for me. I love reading transcripts because that helps me so much position cases. I'll help you organize your all your emails, text messages, pictures, voicemails, videos, so that we can help put it all together and package it nice and pretty so that the judge is not ruling it inadmissible. There's not much. I will just listen to you bitch and moan if that's what you wanted me to do, actually. Excuse my language. But that's what I'm here for. That's what I do. So I also blog weekly. I do these lives every week. I am in the process of writing a few e-guides or e-books that you can purchase and download. I am working on some courses and workshops, which I do workshops regularly, but I'm working on some courses, some online courses. So I'm hoping that you get an idea now. I do offer unbundled services where, some of those services I mentioned, I offer those on a piecemeal basis. So if you just want me to look at a document and to make sure it's written correctly, or it's grammatically or substantively written, adequately for submission, I do that. I can help you prepare a document, whatever it takes. Okay. So that's what I do. That's who Tracy B is. That's the divorce solutionist. That's what we do there. I do offer free consultations, which are 15 minutes long. If you need to find me, I'm on Facebook. It's the Divorce Solutionist on Facebook, on Instagram, and on Twitter, and on LinkedIn. That is where you find me. That's also my website, www.thedivorcesolutionist.com. My email is thedivorcecoach@gmail.com. So there's no excuse. You can find me. I'm findable. I'm findable. Yeah, I make up my own words. But anyway, that is all I have for today. I look forward to meeting up with you guys next week. Until then, bye.